Good evening, class. So I am making this video for my students in South Philippine Adventist College for my subjects, uh, special topics in law. And in this subject, in this video, I'm gonna discuss about the trademarks as part of intellectual property law. So this PowerPoint is not really complete. I have another reference which I will show later, but uh, and I will also give you a copy of the files that I will show you today. So let's start. Okay. So trademarks. So there is really no exact definition of trademarks as stated in our IP code. But we have some definitions there that you can find, and one of it is here, the mark. So mark, this means any visible sign capable of distinguishing the goods, trademark, or services or service mark of an enterprise and shall include a stamp or mark container goods. So mark, any visible sign. So class, just like to emphasize here, diba? Any visible sign capable of distinguishing the goods or services. So in the Philippines, class, the marks that we are the marks that we are uh, protected by law are those that are visible to the eyes. So sa ibang bansa puwede yung smell, scent of smell, ganyan. Meron din yung sense of touch. Pero sa Pilipinas, ang pinoprotektahan lang natin when it comes to sa mga trademarks or service marks ay yung something visible to the eyes. Okay, so I hope that's clear. Any visible sign, yan, capable, and it has to be distinct, or it ha it must be distinguishable. Yan. So, what about collective mark? So, collective mark means any visible sign designated as such in the application for registration and capable of distinguishing the origin or any other common characteristics, including the quality of goods or services of different enterprises which use the sign under the control of the registered owner of the collective of the collective mark. So again, visible sign, yan. And again, visible sign designated as such in the application for registration, incapable of distinguishing the origin or any other common characteristic. So, malalaman mo kung saan siya nanggaling. Yun, class. Including the quality of goods yan. Kailangan ma-identify mo, like, for this particular enterprise, na itong goods na ito yung pinoproduce niya, yung goods na, yung enterprise na ito yung goods na napoproduce niya. Yan, yung goods ay galing sa enterprise na ito. Alam mo yung origin niya. Mamaya i-explain ko sa inyo kung bakit. And yun, it has marks, visible sign. Pwede yan na combination yan ng ng letters, numbers, or other symbols na makikita talaga and madi-distinguish mo as a buyer of those goods or products. Yan. So, trade name. Ito, trade name. Another defined word in our IP code means the name or designation identifying or distinguishing an enterprise. So, sa business na mismo ito. Like, yung name ng business. Yan. So, it must be, yun, nadidistinguish mo siya. So, why is this important, no? So, ito, I posted this question here. Why are trademarks important? And bakit kailangan ma-distinguish mo siya, yung product na ito, na galing siya yung isang goods, galing siya in a particular uh, enterprise which has that trademark or trade name. So why is this important? So bakit kailangan alam mo kung saan nanggaling? So ito. So to answer that, no, in one of the cases in our jurisprudence dito sa Pilipinas, so it stated there the objective of trademark. So I forgot the title of the case here, but the doctrine of the case is the object of a trademark are to point out distinctly the origin or ownership of the articles to which it is affixed, to secure to him who has been instrumental in bringing into a market a superior article or merchandise the fruit of his industry and skill, and to prevent fraud and imposition. So, okay, himay-himay natin, diba? To point out distinctly the origin or ownership of the article. Kung saan nanggaling yung, halimbawa, yung particular goods na yan. Saan siya nanggaling? Ito trace back natin kung ano yung origin niya at sino yung nagmamay-ari, nagpo-produce or sorry, nag-own ng articles na yun in which it is affixed para to secure to him who has been instrumental. Yun. First is para to give credit to the one who introduced the product to the market. Yun. 'Di ba? That from such enterprises skill or industry, yan nag-produce siya, nag-add siya ng value sa market natin through that product that he introduced. Yun. So yun yung first na objective, and second, to prevent fraud and imposition. So para hindi ka agad ma-counterfeit yung product na yun, magaya. Kasi like for example, class, ang product is medicine, no? And then there's ito, yung nilagay ko dito yung mga trademark ng Unilab, ng Pfizer. Yung medicine, halimbawa. So, for example yan, Unilab ang nag-introduce sa market. Ayan, so, binibigyan natin sila ng credit, di ba? For bringing a superior article or merchandise dun sa market. That's one of the objective. And another is yung to prevent fraud and imposition. Kasi paano kapag yung product na yan, madali lang igayahin, i-copy, 'di ba? Eh yung copy niyan, yung kumopya, of course, what do you expect with that product? 'Di ba? Hindi siya ganoon ka high standard kaysa dun sa gumawa mismo kung saan original na nanggaling yung product. And it can in fact, it can be harmful, no? Yung product na yun, yung counterfeit product. So, you as a buyer, di ba? Yung objective ng trademark is to secure that ikaw as a buyer, ma-sure ka na yung binili mo, na gamot or any goods or products ay talagang totoo, original, and quality, no? The quality na pre-namis or na-experience mo na before through that brand, at may provide talaga sa iyo yung quality na yon ng product na yon. Kasi nga, kung hindi galing pala doon, hindi pala galing doon sa original na nagman-manufacture or gumagawa or may-ari ng product na yon, di ba? Anong quality yung maibibigay niya? So, it could be less or it could even be harmful. So, yun yung iniiwasan natin. Kaya, importante na maprotektahan ang trademark, class. So, ayan. So, confusion is likely between trademarks. However, only if their overall presentations in any of the particulars of sound, appearance, or meaning are such as would lead the purchasing public, importante ito, into believing that the products to which the marks are applied emanated from the same source. Yan. Let me highlight this one. In testing this issue, fix yan. There is a there is, however, and can be no disagreement with the rule that the purchaser is confused, if at all, by the marks as a whole. Pero yun ang ano dito yan, dapat yung the public hindi ma-confuse yung public na itong product na ito, nanggaling talaga ito na particular brand or particular enterprise. So, how are rights acquired when it comes to trademark? So, the rights in a mark shall be acquired through registration. Registration. So, hindi siya yung automatic na unlike sa copyright, kasi sa copyright, from the moment of creation ng copyright protected. Dito, you have to register. Pero mamaya i-explain natin na meron din yung tinatawag na first, yung sa first use. Ito, gusto ko lang itong case na ito, Asia Brewery versus SMC. This is San Miguel Corporation. So, dito sa case na to, nagreklamo si San Miguel Corporation laban kay Asia Brewery. Mukha silang akala nyo, same na company lang. Hindi, no? Asia Brewery, ito yung beer na beer. So, San Miguel beer na beer. So, before kasi nagreklamo yung San Miguel beer, bakit daw yung similar, yung parang ginaya, yung form ng bottle nila ng beer na beer. And yung word na pale pilsen. Kasi pale pilsen din yung nakalagay dito sa beer na beer. So sa case na ito, yan, nagsampa si SMC. Ang una talaga nagsampa dito si SMC. And then nakaabot sa Supreme Court. Tapos sabi ng Supreme Court, ayan, it has been consistently held, sabi dito, that the question of infringement of a trademark is to be determined by the test of dominancy. Similarity in size, form, and color, while relevant, is not conclusive if the competing trademark contains the main or essential or dominant features of another, and confusion and deception is likely to result. Infringement takes place. So kahit na hindi naman exactly ganun, pero kapag naging naging confusingly similar na siya, yung marks ng ng goods from another goods or another product, yan. Like yung, halimbawa, same daw yung letter, same yung mga font, ganyan. Halos na ginamit na magmumukha na siya. Pag tinignan mo, akala mo ay isa lang, yan. Pwedeng mag-result ng infringement. So, duplication or imitation is not necessary, nor it is necessary that the infringing label should suggest an effort to imitate. Pero dito kasi, class, nanalo dito yung itong Asia Brewery kasi napatunayan naman na parang iba naman yung pagkaka-form ng letters dito. Like yung sa San Miguel, yung image nila. Hindi ko kasi sure kung ito yung beer na bote before. Wala akong makita na yung pang 90s na beer. Kasi ang case na ito is 1993 eh. So, hindi natin siya totally ma-compare, no? Kung parehas. Pero parang mukha namang hindi. Iba yung pagkaka-font, may SMC. Kasi dito dominant yung San Miguel. Ito beer na beer yung Tapos yung word na pale pilsen dito, hindi niya pwedeng gamitin exclusively on its own sa ng San Miguel. Kasi yung pale pilsen pala is more of descriptive, no? Na pale is yung color ng pilsen, and pilsen is parang lugar siya somewhere in Europe, if I may remember. Yan. So, hindi niya pwedeng gawing exclusive, no? Sa kanya yung word na pale pilsen. So, nanalo dito si Asia Brewery. Yan. So, test of dominancy yung doctrine dito. So, anyway, yun tayo. So, marks which cannot be registered. So, nakalagay din ito sa IP code. So, basahin nyo na lang. So, pero tingnan natin, di ba? Consist of immoral, deceptive, or scandalous matter or matter which may disparage or falsely suggest a connection with persons, living or dead, institution, belief. Yan, sahin nyo yan. Consist of the flag or coat of arms or other insignia of the Philippines, flag ng Philippines, or any of its political subdivision, or any foreign nation, or any simulation thereof. Diba? Flags ng mga bansa. Bakit mo naman i-register yan? Consist of a name, portrait, or signature identifying a particular living individual, o a particular living individual, except by his written consent. Diba? Pwede ko bang, pwede bang portrait identifying a particular, or the same signature or portrait of a deceased president of the Philippines during the life of his widow, if any, except by written consent of the widow. So, pwede siya kung may consent. So, but general rule, hindi pwede. Okay? Number 4 is identical with the registered mark belonging to a different proprietor or a mark with an earlier filing or priority date. Yan. So, kung may naunang nagpa-register sa'yo, yan, hindi mo na pwede siyang ipa-register yung mark na yun. Yun lang yan. The same goods or services, closely related goods, if it nearly resembles such mark as to be likely to cause confusion. So, ito. Ano pa yan? So, as number 5 is identical with or confusingly similar to or constitutes a translation of a mark which is considered by the competent authority of the Philippines to be well known internationally and in the Philippines. Isahin nyo na lang yung ito, and marami pa dito. Marami pa dito yung mga non-registrable mark. So, punta tayo dun sa mag-stop share tayo. Dun tayo pumunta sa isang screen. Okay. Yan. So, ibibigay ko to sa inyo, class. Ayan, nag-record pa din. Bibigay ko sa inyo itong notes na ito. Don't worry. So, ipasadahan lang natin yung mga pinaka-importanting items dito. So, colorable imitation denotes such a close or ingenious imitation as to be calculated to deceive ordinary persons. So, calculated to deceive, no? Kung ordinary persons or such a resemblance to the original as to deceive an ordinary purchaser, giving such attention as a purchaser usually gives, and to cause him to purchase the one supposing it to be the other. Like, for example, class, sanay kang bumili ng, let's say, Colgate, no? Sanay kang bumili ng Colgate sa market, na yung tipong pagdaan mo dun sa market na yon, dun sa alley na yon, kung saan ka kumukuha ng toothpaste, alam mo na kung saan siya mismo nakalagay. Alam mo yung itsura ng product, syempre nababasa mo din, and then alam mo, doon ka kukuha ng toothpaste na part, ganyan. And ngayon, nung one time na bibili ka ng toothpaste, nung pumunta ka doon sa part na yon, imbis na Colgate ang nakalagay, let's say, Colgate. Pero ang spelling ng Colgate, C-O-L-G-A-G-8-T-E. Yun. Isang letter lang yung nabago, Colgate, di ba? So ikaw, ay mukha namang ito yung binibili ko dati, baka ano. Kahit na parang kakaiba, pero ito yung binibili ko. 'Di ba? So, kinuha mo yun, binili mo yun, ginamit mo yun, and yun pala, it turns out that that product is counterfeit. And turns out, what if, no, what if that product is not just counterfeit, but also, delikado pala sa health mo. 'Di ba? So, colorable imitation, sinasabi dito, as to deceive an ordinary purchaser, giving such attention, kasi kapag galing mo, bibili ka, hindi mo naman, yan, giving such attention as a purchase, ano sa ibig sabihin nito? Giving such attention as such purchaser usually gives, and to cause him to purchase to the one supposing it to be the other. So, 'di ba kapag ikaw purchaser ka, nagmamadali ka eh, 'di ba? Unang tingin, yun yung tinatawag na, sa unang tingin, pag tingin mo, kukunin mo na kasi akala mo yun yung product na yun. Without having to scrutinize everything, 'di ba? Hindi mo na gagawin yun. Ikaw, purchasing, kita mo na. That's why, class, a trade name or brand name are very important, 'di ba? Kasi when you already have that experience with that kind of brand, kung meron ka ng experience dyan, hindi mo na kailangan tignan yung lahat ng contents ng brand na yan, yung ano na yan, titignan mo pa ba yung ingredients, saan na manufacture, ganon. Hindi na, kasi may experience ka na, may tiwala ka na. Alam mo na pag bumili ka ulit, you will get the same product. So ngayon, yun yung sorry. So, hindi ka na, pag bumili ka as a purchaser, not much attention na kasi alam mo na to eh, subok ko na to eh, kunin mo na kaagad. Ngayon, may confusingly similar pala. Hindi pala yun. 'Di ba? So, hindi pala yun yung original mong binibili. So, delikado. So, ito, imitation yun. So, yun yung tinatawag na colorable imitation. Okay? So, ito, dito tayo. Registrable terms. Generic terms are those which constitute the common descriptive name of an article or substance or compromise, the genus of which the particular product is a species or are commonly used as the name or description of a kind of goods or imply reference to every member of a genus. Exclusion, basahin nyo na lang to. Ay, ito. Are not legally protectable. Sorry. Emphasize pala natin to. Refer to the basic nature of the wares or services provided rather than to the more idiosyncratic characteristics of a particular product and are not legally protectable. On the other hand, a term is descriptive and therefore invalid as a trademark if, as understood in its normal and natural sense, it forthwith conveys the characteristics, functions, qualities, or ingredients of a product of one who has never seen it and does not know what it is. Ang ibig sabihin ng nito class, yung descriptive, i-remember yung example natin kanina, yung sa case ng Asia Brewery, yung beer na beer, at saka yung San Miguel beer. Yung pale pilsen doon na word, di ba, is descriptive. So, hindi siya invalid as a trademark. Kasi yung pinapa-trademark yun ng San Miguel Corporation. ng SMC, San Miguel beer pala, yun. Pero hindi nga pwede kasi descriptive nga siya, invalid. So, yun. Suggestive terms. Basahin nyo na lang ito. Ito, doctrine of secondary meaning. Ito. Under the doctrine of secondary meaning, a word or phrase originally incapable of exclusive appropriation with reference to an article in the market because geographical or otherwise descriptive might nevertheless have been used so long and so exclusively by one producer with reference to this article that in that trade and to that group of the purchasing public, the word or phrase has come to mean that the article was his produce. So, diba, originally sabi natin kanina, yung mga descriptive terms, hindi siya capable of registration sa trademark. But there are certain words, no, na sabi dito, so long as and so exclusively used by one producer na sa sobrang tagal na ginagamit mo yung word na yon ay nagkakaroon na siya ng so long ng parang exclusivity dun sa one producer na yon with reference to that article in that the trade and to that group of the purchasing public the word or phrase has come to mean the article was his produced. So sobrang tagal na ginamit yung term na yon na ang general public is nagre-refer na yung sa term na yon with respect to the article or to the goods that na pinoproduce ng enterprise na yon. So actually dito sa case na nakalagay dito itong ang hindi siya parang naging hindi siya nagkaroon ng doctrine of secondary meaning. But anyway, so ganun lang yung meaning, yung doctrine of secondary meaning. So just try to familiarize yourselves. Okay? So certificates of registration. A certificate of registration of a mark shall be prima facie evidence, okay, on its face, class. Prima facie evidence of the validity of the registration. Okay? The registrant's ownership of the mark and of the registrant's exclusive right to use the same in connection with the goods or services and those that are related thereto specified in the certificate. So, yun. Duration of protection and rights. So, the rights to a trademark shall be 10 years from registration. So, tandaan natin yan. Yan. Renewal. The rights to a trademark in a certificate of registration may be renewed for a period of 10 years at its expiration upon payment of the prescribed fee and upon filing a request at any time within 6 months before expiration or within 6 months after such expiration upon payment of an additional fee. Yan. Ito, meron tinatawag na class na declaration of actual use. So, ano ba ito? So, the registrant shall file ito. Kahit na yung hindi niya pa talaga na-register, pero matagal niya nang ginagamit. Like, yung, na yan, yung trademark na yun or trade name, yan. The registrant shall file a declaration of actual use and evidence of actual use or shall show valid reasons based on the existence of obstacles to such use within 1 year from the 5th anniversary of the date of the registration of the mark. So, otherwise, the mark shall be removed from the register by the office. Sorry, mali pala yung mali pala yung nasa memory ko na sa declaration of actual use. So, kailangan, kailangan, pag nagpa-register kayo nung trademark ninyo, kailangan gamitin nyo siya, okay? So, yan. Kaya meron dito declaration of actual use, kailangan minamanifest nito na ginagamit mo nga yung mark na pina-register mo. Otherwise, i-remove yun sa register by the office, okay? So, rights conferred. The owner of a registered mark shall have the exclusive right to prevent all third parties not having the owner's consent from using in the course of trade identical or similar signs or containers for goods or services which are identical or similar to those in respect of which the trademark is registered, where such use would result in likelihood confusion. Okay? So in case of the use of an identical sign for identical goods or services, a likelihood of confusion shall be presumed. So, yan, yung rights na kino-confer. Exclusive right to prevent all third parties not having the owner's consent. So, walang consent na ginagamit yung mark na yon. There are similar signs for goods or services. So, right of an owner of a well-known mark. The exclusive right of the owner of a well-known mark which is registered in the Philippines shall extend to goods and services which are not similar to those shall extend to, which are not similar to those in respect with which the mark is registered, provided that use of the mark in relation to those goods or services would indicate a connection between those goods and services and the owner of the registered mark, provided further that the interests of the owner of the registered mark are likely to be damaged by such use. So, what are not included in this right? So, not included in this right, sabi dito, registration of the mark shall not confer on the registered owner the right to preclude third parties from using bona fide their names, address, pseudonyms, a geographical name, or exact indications concerning the kind, quality, destination, value, place of origin, or time of production or of supply of their goods or services, provided that such use is confined to the purposes of mere identification or information and cannot mislead, basta hindi siya makaka-mislead, cannot mislead the public as to the source of the goods or services. Okay. So another thing is important here, dami din yung concepts dito, is yun, assignment and transfer. So an application for registration of mark or its registration may be assigned or transferred. So pwedeng i-assign, pwede ring i-transfer. Kasi yan, property rights din ito, class, di ba? This as an intangible property. Yan, so pwede mo siyang i-convey. Yun eh. With or without the transfer of the business using the mark. The assignment of the application for registration of a mark or of its registration shall be in writing and require the signatures of the contracting parties. Yan. Assignments and transfers of marks shall be recorded at the office yan, upon payment of the prescribed fee. So, sahin nyo na lang yung part na yan. Okay? Cancellation of registration. Yan. So, a petition to cancel a registration of a mark under this act may be filed with the Bureau of Legal Affairs by any person who believes that he is or will be damaged by the registration of the mark. So, pwede niyang ipa-cancel yung registration. So, sino yung magpapa-cancel nito? Siyempre, hindi yung owner ng mark, di ba? Another person. Okay, so general rule, period nito, general rule within 5 years from the date of the registration of the mark under this act. So merong mga exceptions dito, class. Yan. If anytime, ito, basahin nyo na lang itong part na to, yung sa exceptions. And then dun tayo sa trademark infringement. Okay? So any person who shall without the consent of the owner of the registered mark use in commerce any reproduction, counterfeit, copy, or colorable imitation of a registered mark or the same container or a dominant feature thereof in connection with the sale, offering for sale, distribution, advertising of any goods or services, including preparatory steps necessary to carry out the sale of any goods or services. So, i-highlight. Or in connection with such sale as to likely to cause confusion or to cause mistake or to deceive. So, yun yung first ground ng trademark infringement, diba? So, kita nyo naman dyan yung mga terms, diba? Counterfeit, copy, ito na yung colorable imitation, and use. So, I think dito sa Philippines, no, yung pinaka-recent, according to our IPO, isa sa mga, nag-name sila ng top 3 na pinaka-kina-counterfeit, and kasama dun sa top 3, nalimutan ko na yung other 2, pero yung kasama sa top 3 talaga na kina-counterfeit is yung medicines. So, mag-ingat-ingat kayo, guys, no, sa mga pagbili ng medicines. So, only buy from legit sources, no? Mahirap na kapag alam mo kasi kung yung ibang bagay okay lang, like ayun, yung cellphone pala isa doon, cellphone and electronic gadgets, yun yung electronic gadgets, tapos yung sa cellphone, and yung medicine, yun yung top 3 na ginagaya, kina-counterfeit. So, isipin mo kung yun, okay lang yung sa cellphone kasi hindi mo naman siya kakainin, hindi siya papasok sa katawan mo. Pero delikado din yun kasi baka sumabog, di ba? Yun naman yung ano doon sa mga gadget. Kung bibili ka ng counterfeit, baka sumabog, hindi mo alam. Delikado din. Pero yung like yung sa mga medicine, mas lalo ng delikado kasi bibili ka, tapos yun pala counterfeit, no? Hindi lang basta less quality, kundi baka dangerous pa sa health mo yung mabili mo. So, imbis na gumaling ka, nagkasakit ka pa lalo. So, ingat-ingat guys. Only buy from legitimate sources. Yun. So, reproduce. Ito number 2. Reproduce, counterfeit, copy, or colorable imitate a registered mark or a dominant feature thereof, and apply such reproduction, counterfeit, copy, or colorable imitations to labels, signs, prints, packages, wrappers, receptacles, or advertisements intended to be used in commerce, upon or in connection with the sale, offering for sale, distribution, or advertising of goods or services, on or in connection with which such is likely to cause confusion or to cause mistake, yan, shall be liable in a civil action for infringement. Yan. Civil action for infringement by the registrant for the remedies herein set forth, provided that the infringement takes place at the moment any of the acts stated in subsection 1551 of or this section are committed regardless of whether there is actual sale of goods or services using the infringing material. So the moment class that you reproduce a counterfeit copy or a colorable imitation, yan, regardless pa yan kung naibenta mo yung product or hindi. So, infringing na yung material, yung ano na to. So, what are the remedies? Yan, remedies for trademark owner. So, number 1, yan, trademark owner, it can recover damages which shall be based on the reasonable profit which the complaining party would have made had the defendant not infringed his right. So, or the profit which the defendant actually made out of the infringement, or in the event such measure of damages cannot be readily ascertained with reasonable certainty, then the court may award as damages a reasonable percentage based upon the amount of gross sales of the defendant or the value of the services in connection with which the mark or trade name was used in the infringement of the rights of the complaining party. So in cases where actual intent to mislead the public or to defraud the complainant is shown, in the discretion of the court, the damages may be doubled. So, yan. So, syempre ikaw yung original producer talaga, di ba? Ng product na yon. And then, you lost profit kasi may naggaya, may nag-counterfeit. Yan. So, may nag-infringe nung product mo, nung trademark mo. Ngayon, syempre, whatever profit na makukuha mo sana, yan, pwedeng i-award sa'yo. Yan. Or kung hindi ma-identify kung how much talaga exactly, the court can give a reasonable percentage based on the amount of the gross sales of the defendant or yung value of the services. Yun. So, yun yung first. So, number 2, yan. Ito, number 1, yung recover damages. 2, seek injunction. And 3, seek the destruction of infringing materials without compensation of commerce and avoid any harm caused to the right holder. So, at hindi lang ito sa right holder class, di ba? Ang destruction ng infringing materials could also be beneficial for the public as a whole kasi nga yung yung product na yun hindi substandard siya, hindi siya yung yung ine-expect ng public na talagang magpo-provide ng quality na hinahanap na particular brand. So, it's also for the public kasi it might cause harm to the public yung product na counterfeit. So, yun. Provisional remedies, criminal search and seizure, civil search and seizure, the court may impound during the pendency of the action. Yan. And sales invoices and other documents evidencing sales, then preliminary injunction. So, yun. So, meron ditong concept na tinatawag na prior user in good faith. Ito, importante ito, class. So, a registered mark shall have no effect against any person who in good faith before the filing date of the priority date was using the mark for the purposes of his business enterprise. So, prior user, provided that his right may only be transferred or assigned together with his enterprise or business or with that part of his enterprise or business in which the mark is used. So, itong prior user in good faith na tinatawag. Before ka pa na-register yung mark, may isang gumagamit na pala na itong mark na ito, no? In good faith, wala naman siyang ill intention sa paggamit. So, wala siyang knowledge na merong other na nakaka-possess din ng same na mark, no? Similar. So, yan, basta ginagamit niya lang yung mark na yon solely for the purposes of his business enterprise. So, kung ano lang yung particular na gamit dun sa business niya. Yun lang. Dun niya lang pwedeng gamitin. So, yan. So, ito, border control. No article of imported merchandise which shall copy or simulate the name of any domestic product or manufacturer or dealer or which shall copy or simulate a mark registered in accordance with the provisions of this act or shall bear a mark or trade name calculated to induce the public to believe that the article is manufactured in the Philippines or that it is manufactured in any foreign country or locality other than the country or locality where it is manufactured shall be admitted to entry at any custom house of the Philippines. So, kasi yung si customs kasi yan eh. Kaya ito class, yung IP, yung, yung IP office natin, it works hand in hand with other agencies and one of that agencies is government agencies, yung sa Bureau of Customs natin. Kasi, ayun eh, yung baka may pumasok dito. So, dun pa lang hinaharangan na. Dun pa lang sa entrance dito sa Philippines, ng mga goods na yan. Okay, so, in a while, so, i-discuss din natin yung copyright maya-maya. So, but for now, with this video, so thank you for listening to our shortcut version of discussion of trademarks. I hope that somehow meron din kayong natutunan kahit papaano dito sa discussion natin. But don't limit yourself with our discussion. Read and read. Read the IP code that we have. Visit the IPO website so that you can learn more. And yun. So, thank you so much for listening and God bless you guys. So, I will stop the video.